開會。
We have a quorum and it is the appointed time. May I call to order the meeting of the panel on constitutional affairs. Let us invite the administration to come in.
做一陣小販先返過嚟啦。好，會議議程第一。
Item 1 on the agenda, information papers issued since the last meeting. There were none. Item 2, items for discussion at the next meeting. The next meeting will be held on the 21st of July 2014 on Monday at 2:30 in the afternoon. What would you like to discuss with us, Under Secretary? We'd like to propose 2 items for discussion at the next meeting, and also to listen to members' views. Number 1, ineligibility for candidature and related matters pertaining to persons not having served full imprisonment terms. In June 2012, the Court of First Instance handled and also ruled on 2 judicial review cases on whether people who have not served out imprisonment terms can become candidates as legislative councils. According to 39(1)(b), it is ruled that that particular section is unconstitutional. In July, the administration would like to consult members of the public on the matter. That is why we would like to introduce the paper to members for comments, and hopefully before the next cycle of district council elections we can amend the relevant ordinances. This is number 1. Number 2, the 3rd report of the Hong Kong SAR on CEDAW, C-E-D-A-W. At the end of October, the SARG will send a delegation to the meeting. We hope to listen to views of members and deputations in the July meeting. Okay, you will prepare papers for us, is that right? The candidature paper. Yes, indeed. Mr. K.K. Fong. Recently, the State Council released the white paper. I'd like to discuss it. That is about the practice of one country, 2 systems in Hong Kong. And I think it is related to the CE and also LegCo elections. I think there is a big difference in the understanding of one country, 2 systems between the central authorities and Hong Kong. And it is said that now judges have become administrators as well in Hong Kong. I think that is an important paper and we should discuss it. Even if we don't have time, let us arrange for a special meeting. My understanding is that on the 25th of June, there will be a question asked on the white paper. Under Secretary, can you introduce the paper and discuss it with us? Mr. Chairman, that white paper is released by the State Council. So we will not have a detailed discussion here. However, we understand that this week officials of the State Council will come to Hong Kong to do some explanations. And as you said, next week there will be an oral question. Will you invite all LegCo councillors or at least panel members to that briefing? Let's see. We are waiting for the relevant officials to come this week. We'll take a look at the overall arrangement. Mr. K.K. Fong, that kind of reply is unacceptable. The paper is released by the State Council, but as the SARG, you should understand and comprehend the paper. You are the executive of the SARG. Even if it is not a formal meeting, there should be an informal meeting. The oral question is not a discussion. The President will always say, refer it back to the panels, so it will eventually come back here. It is an important paper. How can we deal with all the questions we like to ask within 20 minutes? Therefore, as the SARG, you have the responsibility to arrange for central officials to come here to LegCo, or you do that on their behalf. 2 officials will come to Hong Kong. Chairman, you asked him, but he could not reply to you. Well, he is not sure whether we will be invited. He cannot reply to you now. Well, I can put that aside, whether the 2 officials will meet us. But as the Council and also the panel on Constitutional Affairs, can we request a meeting on the white paper? Whether it be the Secretary or other experts who will come to the meeting is up to you. I mean the administration. Mr. Sin Chung Kai, let me also listen to you. First, I'd like to agree that we should discuss the white paper. The most ideal thing is for Chinese officials to come here to explain the policies to LegCo members. Even if they don't come, if LegCo members can go to other meetings, in fact, that has nothing to do with this panel. But the ARG needs to explain something, because we'd like to know whether the paper has been incubated for a year, and in the last year whether the SARG has had any input into the white paper. I don't think the central authorities has worked behind closed doors. I'm sure it's well-intentioned. It must have asked for the views of the SARG. I'd like to know whether the SARG has given input to the central authorities vis-à-vis what should be included in the white paper. And also, did you see the draft? I think you should explain to us all these matters. Mr. Raymond Chan, I of course support KK Fong, but I'd like the administration to tell us clearly something. This is not a legal paper. It is a policy paper of the central authorities. I'd like to roll of the CMAB vis-à-vis this white paper. Whether or not we have a meeting, it doesn't matter now, but you must tell us whether you were involved and in what role. Under Secretary, what are your replies? Chairman, I can only say that this is a paper released by the State Council. That is a fact. And next week there will be an oral question. Of course, members also put forward different views. I will reflect them to the Secretary. Okay. He will go back and liaise with the Secretary. We'll see what can be done. Did you have any role in it? He said that this is a paper released by the State Council. Okay, let us know if you have any news. If there are no other questions, so those will be the 2 items. If there will be more items, we'll let you know. Let's go into the agenda proper today. Hearing of the 3rd report of the Hong Kong SAR under the International Covenant on Economic, Social and Cultural Rights. We have 2 papers that have been issued to you. One CB-2 1758/13-14-03 paper from the administration. 04, that is a background brief prepared by the Secretariat. Under Secretary, please walk us through your paper. Thank you, Chairman. The UN Committee on Economic, Social and Cultural Rights held a meeting in Geneva on the 8th of May 2014. The SARG delegation attended that hearing, and we replied to certain matters. The committee on the 26th of May released the concluding observations in draft form. This is also listed as one of the list of issues in the committees. On the 27th of May, we released a press release in order to make initial response. And however, we still needed to do some other work, and that has been forwarded to relevant bureaus and departments. The next time for submission of report is in 2019, and members' valuable views will always be welcome. Okay. Any questions? Raymond Chan has raised his hand. 5 minutes each. All right. Mr. Raymond Chan. Chairman, the UN committee starting from 1996 has asked the SARG to take measures in order to remove discrimination against sexual minorities. That has been for the 4th time now, and the wording has become even more strict, and that is to ask the SARG to expressly make laws to remove discrimination against sexual minorities.
All along, the administration's response is that there has not been planned to enact legislation. So they have disregarded the responsibility as a ratifying place. Yesterday, many people in support of homosexuals organized an event, a Pink Action Organization activity. More than 12,000 people participated in the activity. So the message is clear. They support equal rights for homosexuals. It seems that the government has not done enough. They have not listened clearly to people's views. They said that they would make use of publicity and education and other softer means to eliminate discrimination against sexual minorities. This is definitely not enough. A lot of opinion polls state that there is the need for legislation to eliminate discrimination. So I would like to ask the SARG. Every time when the UN asks you to take actions, you repeated the same points. You said there is not any plan to enact legislation. Can you face up to this issue? Can you stop evading? You don't have any plan to enact legislation. Can you tell us a timetable? Can you tell the Hong Kong public that even though you cannot enact laws today, are you going to conduct a consultation? Will there be a consultation period? Will there be preparation work for legislation? Instead of saying every year that you will make use of education and publicity to eliminate discrimination. You have talked about these for so many years, but discrimination has not been eliminated. We don't see significant improvements. Under Secretary. Thank you, Chairman. Thank you, Mr. Chen. Thank you for showing concern for this matter all along. Mr. Chen is a member of the subcommittee on eliminating discrimination against sexual minorities. We have not evaded from the issue. We understand that this matter has generated different views in society and a lot of controversy. Each step taken is very sensitive. So that's why we have set up a subcommittee inviting different stakeholders and people with different perspectives to sit together to engage in a very calm and rational discussion to see how this matter can be dealt with. Just because we want to face up to this issue, have we set up a subcommittee. This subcommittee has met 4 to 5 times already, and some APIs have been produced. Now an in-depth study is being done. 200 sexual minorities have been invited to join a meeting. The results of this study in the coming few months will be released. So in Hong Kong, for the first time, there is going to be a detailed study on discrimination against sexual minorities. And there will be more in-depth understanding of rational exploration on this basis. I think this is a very responsible approach. Mr. Chen said that education and publicity is not effective. But I can tell you, on anti-discrimination issues, education and publicity are always useful, but that's not enough Yes, so that's why we need to step up our efforts. Those people who are participating in this subcommittee can continue to give us their views. I would like to repeat a point. I think Mr. Chen will also agree that this topic is very controversial. There are both people for or against legislation. Under Secretary, I think all government policies are controversial. If you say that you won't work on controversial matters, then you don't need to do anything. So you need to narrow the differences by means of consultation to remove misunderstanding. If you want to only legislate on things and work on things only when there is no controversy, then you don't need to do anything. Chairman, we have been following up things and we have been working. Next, Ms. Sit Ho. About rational discussion, I think things are getting more and more irrational. Yesterday, on the internet, there are people with religious background who spread a prayer. Yesterday, at Tamer Garden, there was the event to support equal rights, and according to that prayer, it is stated that they don't want people to go to that venue to receive adverse message. So they are praying for bad weather because there's a typhoon yesterday, so that people could not go. And there's another paragraph saying that it was Father's Day yesterday, and so they didn't want people to be affected. So I don't know what the ultimate goal is. It is very fortunate that yesterday during the event there was no rain, and it rained only after the event. Now, when it comes to the so-called rational discussion, it is really irrational. So I think the government has the responsibility to clarify things. You should promote rational understanding and awareness. So people should not pray for bad weather and rain so that people won't get the message. That's not the right way. The government would like to make use of education to eliminate discrimination. But actually, in a lot of public administration areas, there are different treatments for people with different sexual orientation. For example, the application for inheritance. Because there is no registered relationship. So when one passes away, the other spouse cannot take over the estate, as in other cases of married couple. Besides, in hospital, the spouse does not have the right to sign to give consent for his or her spouse to have medical operations or treatment performed. So does the government admit that these different treatments are discrimination? If you don't admit that this is discrimination, if you don't admit that this is limitation in the law, depriving people of equal rights, then how can you educate the public? How can you promote anti-discrimination in society? Under Secretary. Chairman. Government departments in receiving or handling people's applications and requests follow the law. So in the law, there are some rules and some provisions. Everybody abides by those provisions. Ms. Ho said that there should be rational awareness. I agree totally. I haven't touched upon this matter a lot, but as I said at the beginning, I think this is a very heated topic. There are different views. People have expressed different points in support of their views. Of course, we hope that the subcommittee can become a very rational platform, but at the same time, we hope that different community groups can also be rational and calm in their discussion. I hope Ms. Ho will agree to this point. But, Chairman, if you only say that based on the existing policies and laws you will do the work, but you have to first admit that there is discrimination in the existing laws and policies, because there is definitely unequal treatment. There is a couple registered getting married overseas. If one of them is not a permanent resident of Hong Kong, please tell me whether he can apply for family reunion. It's just because these two people are or belong to the same sex, so they cannot apply for family reunion. Is this discrimination? You have to first admit that this is discrimination in policies and laws. You have to change first. Otherwise, if you don't change, how can you change the society? Under Secretary, now we do have the law about marriage between people of the same gender, and every department complies with the law in implementing the policy. So I don't see any discrimination elements in our work. Mrs. Regina Yip, Chairman, I want to ask the administration about their views on civil marriage. Now, I understand that some consulate generals help their citizens to arrange this in Hong Kong. That's also my understanding. So what is the government's view in your policies? Under Secretary, if you talk about other countries' consulate generals, they have their own laws. They have different practices. In Hong Kong and in other places, different consulate generals, different consulars have different rules and restrictions. So in Hong Kong, sometimes these consulate generals will have communication with the administration. So we will go according to the communication and agreement with different countries. Mrs. Yip, so let's say if at the French Consulate General there's a civil marriage, and then under the French laws this is being recognized, but then in Hong Kong it's not valid. Is that right? Under Secretary, Chairman, we have also to look at well, this is not only a matter of their laws. We also have to consider local laws and also that particular country's legal provisions to see how territory in which the Consulate General is situated governs this thing. So I think there is this overall comprehensive consideration. Can you give a written response? Because I don't quite understand. So let's say if there is a civil marriage registered according to a certain country's laws, then that is valid in that country. But is this valid under our marriage ordinance? Can you give a written response? I don't think the situation is as complicated as described by the Undersecretary. I want to know what kind of rights and interests can this married couple enjoy in Hong Kong. Next, Ms. Starry Lee. Thank you, Chairman. In Hong Kong, the marriage system is one between one male and one woman, so between two persons. There will be a lot of discussion in society if it is to change. And I don't think that implementing the existing legal framework will lead to discrimination. Now the government has set up a subcommittee to study this. I hope the Undersecretary will be fair and impartial. Now there are different relationships in which people cannot inherit the estate. Where there are long-term cohabitants, they are actually like couples, but then if they have not formally get married, they cannot inherit the estate. And if a person is willing to be let's say, mistress of a person, she still cannot inherit the estate of the deceased man. So there are a lot of these circumstances. I hope the Undersecretary will be careful in handling these matters. About discrimination, there is one case. In society, there are people discriminating against the mainland visitors. So I want to know whether you have followed things up according to existing laws, have these people contravened any law? Under Secretary. Thank you, Chairman. Just now, Ms. Lee talked about these people who are discriminating against mainland visitors. Now, at EOC, there are 4 anti-discrimination laws. One is racial discrimination law. Now, when mainland people come to Hong Kong, they are all Chinese. They belong to the same race. So we cannot make use of this law to take any actions. But we know that the EOC will do some review and they will consult society very extensively. Sorry, I would like to follow up. Under Secretary, you said that there will be consultation and following up. So are these reviews or are these follow-up actions mainly against these people who are trying to drive away the locusts, so-called locusts? Well, these are things that will be done by EOC, including the circumstances that you just mentioned. Chairman, since we attach importance to different types of discrimination and people who discriminate against others, I think this is quite serious. About these anti-locust people, I think this already constitutes discrimination.
I hope you relate this to the EOC, so they will find a way to handle the matter to see whether it constitutes discrimination. Under Secretary, that's a remark. Wang Ting-Kwang. Thank you, Chairman. I'm aware that the committee proposes to remove the 2-week rule for domestic helpers who have just finished the contract and also the live-in rule. I'm very concerned about this. Once the 2-week rule and the live-in requirement are removed, then many more FDH will put up very poor performance, hoping to be fired. If this is really the case, I'm sure the situation will deteriorate and things will get out of control. I'm also worried that without the live-in requirement, since the nature of the work of FDH is so special, there will be a big impact on the families, especially those with small babies who need to be taken care of by the FDH. The parents have to work in the daytime. If they do not have a good night's sleep, they will not be able to work properly in the day. They ask for FDH's help really to look after the babies. If there is no live-in requirement, these families will be in great difficulty. What is your reply to that? Can you reassure us? Or will you insist on the original arrangement? Can I defer to the LW Bureau? Mr. Chow Wing-hang, PAS. Yes, Chairman, Mr. Wong. The administration will maintain the 2-week rule because we need immigration protection. We have reiterated that stance in information furnished to the committee. The SARG also explained to the committee that we have already got different kinds of protection for the rights of FDH, and we have already struck a balance. For example, they are protected by the Employment Ordinance, and also their rights are protected by the Standard Contract of Employment. We have also provided information to let the committee know that FDH have to comply with this live-in requirement because of the special nature of their work. FDH need to live together with the employer's family. Our position has been explained to the committee, and the live-in requirement has already been explained to the public when we enacted the statutory minimum wage. Mr. Wong, as for the 2-week rule, I hope the Bureau will look into the real situation. I think the Bureau is not enacting the requirements strictly. Sometimes they only go to Macau or make a round to Shenzhen. But when it means to leave Hong Kong, I think they should go back to the place of origin. Only so can we ensure that they will not conspire with agencies to put up poor performances so that they will be dismissed. Because in that way, the agencies can cheat the employers of the fees. PAS for security, Ms. Wong. Thank you, Chairman. And question. When the Immigration Department vets applications by FDH, it will look at the previous immigration record and also the record of work in Hong Kong. If it is discovered that the FDH has abused the early termination of contract arrangement, then when their applications are vetted in the future, this will be taken into consideration. When the Immigration Department vets such applications, very often the employers would like the Immigration Department to do it as quickly as possible so they can get some domestic help. And therefore, the Immigration Department has to strike a balance between those two interests. Next, Ms. Ann Chang. Thank you, Chairman. I can see from number 50, which is on mental health and lack of medical personnel in the public health sector. We all know that in Kai Ching Estate, Wing Chang Street, and also in Mong Kok, there was the throwing of objects from a height. A young person was struck to death accidentally. These are very sad events. Last year, I put in a question to ask about the manpower complement for taking care of mentally ill patients. I understand you only have like 300 psychiatrists. In 2012 and 2013, we have an increase of 30,000 patients. They are standing in a long queue. In Kowloon East, the queue is longest. They have to wait like 4 months. If indeed there is a big mental problem, the delay may mean a failure of the medical treatment. So I'd like to know the ratio of mental health workers vis-à-vis patients, and how do we compare with other countries? Is there really a serious shortage? We also know that there are rehabilitated mental patients who live in the community. But it seems the social workers have said that there is a lack of manpower as well to take care of these rehabilitated people. And it happened that the carers themselves are under great psychological and physical stress. There was a survey showing that over half of the carers said that indeed they were very much tired because they had to care for the mental patients. So how do you assess the situation in order to improve the present situation? Mr. Chung, PAS for CMAB. According to information from the FH Bureau, it says that it places a lot of emphasis on the matter. Now it has a intersectoral and interdepartmental effort to tackle the problem. The Hospital Authority, Department of Health, NGO, and other stakeholders, as well as 2 other bureaus. are working to promote mental health in Hong Kong. And regarding the service mode, there will be prevention, early identification, early intervention, and treatment, so as to provide service. Ms. Chang asked the question, and the FH Bureau indeed places a lot of emphasis on this. It has already set up a review committee on mental health. It is headed by Dr. Ko himself. And the membership includes representatives from the LegCo, the academia, the medical sector, service suppliers, service users, and also carers, as mentioned by Ms. Chang. The EOC and the Hong Kong CSS are also represented. The committee will mainly review mental health policies so that they can draw up a way forward for mental health service in Hong Kong. They will think of ways and means to strengthen mental health service for the public. The review work is underway. At the appropriate time, they will publish the results of the deliberation of the review committee. At the same time, in terms of shortage of doctors, the administration has taken a multi-pronged approach to tackle this, including doctors trained in Hong Kong. The 2 medical schools continue. Turns out 420 graduates every year. At the same time, they are thinking of other flexible means. For example, giving a limited license to overseas doctors to practice in Hong Kong. Next one, Mr. Yu Si-wing. Thank you, Chairman. I also like to talk about tourists. Mainland tourists do take their suitcases to tourist spots. Well, let's say to a certain extent we discriminate against mainland tourists. Sometimes they follow the mainland workers, and then when there is a small boy appearing in the street, they will take photos. This is to a certain extent discrimination, but according to the Undersecretary, we belong to the same race, so this is not racial discrimination. When you conduct consultation with the public, how will you do it? From what angle will you do it? Secondly, according to the right to work, this is in Section 6 of the Covenant, and I'm talking about refugees. They have asked whether refugees will be allowed to join the labor market and whether they will be able to receive tertiary or professional training. I don't know whether you will adjust our policies towards refugees. As you know, they are a big financial burden on Hong Kong. Some of them have also caused law and order problems. If we give them even more support, what will be the result? Will more refugees come to Hong Kong? We also know that very often the UN wants Hong Kong to be more generous. They say we should accept more refugees. I knew that they should help to foot the bill, but they have never paid up. But at the same time, they ask us to give more support to refugees. I don't know whether the SARG will ask the UN to pay up their old debts first before asking us to do more. 2 questions. Undersecretary. Chairman, on refugees, I'll ask the Security Bureau to reply. As for tourists and what they have encountered, the consultation and the review is not being done by the administration as such, but the EOC is preparing to do it. We will relate your view to the EOC, and at the appropriate time, I believe they will come to LegCo for a discussion. I will now relate your view to the EOC. Ms. Wong from Security Bureau. On refugees, whether they can work in Hong Kong. In February 2014, the Court of Final Appeal has already ensured that these people who have the non-refoulement claim cannot work in Hong Kong, and we have adopted the same practice. But in very special circumstances, for example, the refugee status has been confirmed, then the Director of Immigration has the discretion to allow these people to work in Hong Kong, but they must comply with certain conditions. You talked about old debts. All along, we have been pursuing the UN for what we should get back. We'll continue to do it. Mr. Yu Siwing, any follow-up? Sometimes I think it's so easy for the UN to write a report, but I think they live in an ivory tower. Different countries and places face different problems, and they seem to think that the situation is so easy.
After a report is issued, apart from the government making explanation, I think they should send people to take a look, because there may be misunderstanding in society, thinking that there's no human rights in our society and we have not discharged our international obligation. So since there's this report, I suggest that the government should talk to the UN to clarify that there are things that we have done. And also, there's ruling by the court. I see the same issue on many items and points. So, okay, they have made recommendations. We can try our best to improve. There are some objective circumstances. They should confirm that we have done a good job, and then they should then come up with a very objective and reasonable view. Under Secretary, I do agree with the member, because there should not be a one-sided remark. I think both parties should clarify the facts. Actually, the SARG before the hearing has explained or has given an account on our human rights situation and all the improvement measures. And there are some items that have been well recognized by them. Of course, there should be improvements in our human rights condition, and the next review will be in 2019. At that time, or before that, people can still give views. I have attended a number of such meetings. In that committee, there are human rights experts. They have made some points. There are things that we can improve on, then we can take some actions, but then there are also things that are actually facts. So we have to set things out very clearly. Next, Ms. McMay-Kun. Chairman, Mr. Yu said that he hopes that the UN can assess the situation in Hong Kong very clearly. If you talk about item number 7, a good working condition, I think over the years the government has not really done much. If you refer to para 45 about legislation on standard working hours and overtime work pay, and then rest day or unfair dismissal, all these have been discussed for a long time. But now there's only a working hours committee. And we know that that committee talks about standard working hours as regards statutory overtime work pay and also rest day. Now, rest day is not about working hours. When we legislated on minimum wage, there's disagreement on lunch hour pay and also rest day. And there's also the point about unfair dismissal. So these labor issues have been discussed for a long time. The Bureau has read the UN's report, recommendations, and so on. So is there anything that can be done immediately? There is another paragraph on collective bargaining right. So, Mr. Chow of the Bureau, thank you, Ms. Mack. About the Standard Working Hours Committee, they are now doing some practical work. For example, there's a consultation on standard working hours. In-depth studies are being done. They are communicating and exchanging views with different stakeholders. We understand that this is a complicated and important matter. Apart from looking at labor rights, we also consider existing employers' arrangements and also SMEs' views. We will relay points to the committee. And then about unreasonable termination or unreasonable dismissal, now in the Hong Kong human rights laws and labor laws, there's protection for people taking part in labor union activities. So if they are unreasonably dismissed, the employer must re-employ them or compensation must be made if it is deemed an unreasonable dismissal. So now the Labor Department enforces these rules. Last year in December, we made a presentation to the Manpower Panel. We're arranging law drafting on re-employment, and the Labor Department is working with the Legal Department to review the drafting. So if there is any progress, we will give an account to the panel. Ms. Mack, now concerning statutory overtime work pay, rest day, and also collective bargaining rights, what kind of work will the government do apart from the Standard Working Hours Committee? Mr. Chow? Chairman, about collective bargaining, now the government is promoting a voluntary collective bargaining. Now, in different industries and different tasks, they make use of collective bargaining to agree on wage adjustment, including the construction industry. For these voluntary collective bargaining, the Labor Department will continue to promote that. As regards mandatory collective bargaining, in society, there are mixed views. And in the past, there are a number of times in which LegCo had motion debates on mandatory collective bargaining, but then the motion was not carried. So the Labor Department will continue to follow up on voluntary collective bargaining. As regards working hours, public holidays, statutory holidays, and so on. Now, concerning meal or lunch pay, would that be incorporated into the statutory minimum wage? The government explained to the public in the past that in different employment contracts, whether or not lunch pay should be included in minimum wage, there may be different rules in different companies. And when we legislated on minimum wage, we explained to LegCo that we do not have any plan to supersede employment contracts in relation to that lunch pay. So we have already explained our position. As regards public holiday or statutory holiday, it depends on the contractual rules. The minimum wage law doesn't say rigidly whether that should be calculated or included in minimum wage. You want to follow up? Now, concerning rest day, we now have statutory holiday and public holiday. So among employees, is it true that this is already inequality? So we won't have good and fair working conditions as in Article 7 because employees will be classified into different categories. So should public holidays and statutory holidays be unified? Mr. Chow, thank you, Ms. Mack, for your comments. I don't have the information with me now. I will contact the Labor Department and later on I will give a response. Okay. Any other questions from members? If not, then we will end this item here. Let's move on to the third agenda item, and let's invite the government officials to come in. Item 4, progress of following up on the Law Reform Commission's proposal on stalking. And 2 papers were given to members. First, CB bracket 21758/1314 bracket 05 and bracket 06. That's a background brief on the topic prepared by our Secretariat. So I will invite the Under-Secretary to present the government's paper. Under-Secretary. Thank you, Chairman. Last year in December, in the panel meeting, we reported to panel members that we have commissioned a consultant from Hong Kong U to undertake this study. After listening to members' views, we have done some follow-up and analysis work. So we hope to make a report at this meeting. LRC recommended a public consultation, and all along, the focus of the public is on possible impact on freedom of the press. At that time, during the consultation period, stakeholders from the media and also from women's groups are concerned whether freedom of the press and freedom of expression would be affected, and whether there should be a law on anti-stalking behavior. There has not been public consensus. After receiving these concerns, we have asked the consultant to review all these points. Now, the consultant has taken reference from overseas experience concerning exemption on journalistic activities. Stakeholders are concerned that overall exemption will undermine very significantly protection for the victims. Now, even with exemption, journalistic activities will also be affected. And there's another explored option, and that is between certain people with specified relationship, for example, within the family, between the landlord and the tenants, and then between the creditors and debtors. These are some relationships mentioned by LegCo members. So stalking activities should be criminalized among these relationships. But then if you look at the law, if we only criminalize stalking behavior for these people in these relationships, is not proper, because the law should be equal to people in the same circumstances. So if stalking is an offense, then all stalking activities, no matter whether it is among people in those particular relationships, should be dealt with in the same way. And under the law, these activities should be punished in the same way. So in the future, we think that we have to abide by the fairness and equality principle. We should treat people in the same way in offering the same protection to the victims. And then journalistic activities should not be overly restricted by the new law. But so far, there is not an option that has got support by members of the public, members of the committee, as well as different stakeholders. So we will consider members' views at this meeting before we make a decision on the way forward. Thank you, Chairman. 2 members have raised their hands to ask questions, so 5 minutes for each. Ms. Claudia Mo. Thank you, Chairman. Just now, I heard that you want to be fair and you want to be impartial, you want to be equal in treating people. So I'm happy to hear that. But it is quite regrettable that in northeastern new territories there's still not been a consensus, but then the government insists on not withdrawing the FC proposal. So why can't the government be consistent in your attitude instead of having one government but two systems? You talked about landlord-tenant and creditor-debtor relationships, and then you also mentioned the domestic violence law. You said that it is not appropriate to criminalize stalking activities among people in these relationships. But the legal sector asked why not? Why is that inappropriate? Secondly, the media is very happy that there won't be this stalking law. You can imagine that we are not saying that freedom of the press is the king. Let's say there's a group of reporters gathering at your door. And then if there's the stalking law, you can call 999, and then the police officers may come, and then they can follow the law to drive away these reporters.
However, if there is not even the basic news gathering right, and the victim, so-called victim, will not report on the reporter's stalking, then there will be no court case. However, you already cut off news gathering freedom. I have talked to the Undersecretary about the same thing. If you say we have exempted the press, there will still be this problem. Even if the case goes to court, well, people still have to defend themselves in the court. If I'm the editor, you are the reporter, do I have the right to say you may break the law if you do this? But wait till we get to the court. I think this is unfair. And the last point is, why is the press above the law? We don't need any exemptions. We don't want to override the law. The press just want to engage in proper, normal news gathering. You do not say too much about the timing here. You are quite vague in saying that it depends what people think, and then you will make a decision on the way forward. The Hong Kong Journalists Association insisted that the stalking law is usable in protecting privacy, and they have asked you to separate the different provisions and get on with some. Say, if you go for the domestic violence ordinance, and also can you not tackle debt recovery between landlord and tenant, and between moneylenders and lenders and borrowers? If you say it's too difficult, then can you also verify what I read 2-3 months ago, that there was an exclusive report saying the stalking law is already dead? Undersecretary, thank you. Ms. Mo. As you said, in our society, whether there should be exemption for news gathering, there are diverse views. In fact, there are quite a few stakeholders saying that the press should not be exempted, that there should be equal treatment. But of course, there are organizations saying that press freedom is extremely important, and it is not easy to find a consensus on this point. Ms. Mo talked about some specified relations and asked why it is inappropriate. There are a few reasons. Number one, we are talking about interpersonal relationships, and in fact, stalking does not only relate to these 3 relationships. There are so many other relationships. Why don't you go for these 3 first? If we only tackle those 3 as a first step, that goes to show even more that there will not be equal treatment, so it is inappropriate. Number 2, in certain circumstances, the 2 parties do not know each other. There is no relationship at all. Number 3, we have looked at overseas experience. There is no such law, and that is on the basis of specified relations. Therefore, according to what members said last time, I think this is not feasible. Is it that it is now dead? Should we describe it that way, Undersecretary? Today, as you can see, we are very cautious and sincere. We have had a few meetings. We also looked into issues raised by members. We are very frank with all the problems, and we have told you what we are facing. We like to listen to members first before we make a final decision. Next, Ip Kok Him. Thank you, Chairman. Indeed, in these 10-odd years, there has been a lot of controversy about stalking. There are diverse viewpoints. More people are concerned about being stalked because of debts and unrequited love. This can be very disturbing, and sometimes rather sad events can result. Some people have been hurt physically, and in fact, lives have been lost. So to many members of the public, they will ask, why cannot the law protect them? We have seen cases where people report to the police, but there is no law for the police to act on, because the stalker has not broken any law prima facie. The stalker may call you up, the stalker may wait for you in the street. The stalker can also do other things, and victims' work can also be affected. So there are strong views on this. And of course, the press have spoken up to say how they can do news gathering and to also expose facts to the public. In the process of news gathering, sometimes some people can employ outrageous means, for example, stealthily filming people, etc. Here in the paper, you say that for the time being, you are going to shelve the stalking recommendation. So in this circumstance, do you have other means in order to tackle what I was saying? Or else the public cannot be protected. There may be controversy, but do you have laws to protect the public's privacy and also people's safety? You say you want to listen to views again, but I think you have already decided on a direction, and that is to shelve the proposal. But I'd like to know whether you have other measures to tackle the situation. In other words, to still protect people legally. Undersecretary, thank you for that view, Mr. Ip. This is indeed what we have thought about. But stalking has been regulated by many other rules and regulations. As Mr. Ip was saying, if you continue to call up somebody, then there is the offense of non-stop telephone calls. And in 2013, there was a case which was convicted on the basis of continuous calls. And also in September 2013, there was a texting of message on the phone. And again, that was regulated by the offense of posing a threat by continuous messages, text, The LRC actually knew this. It was only saying that this might not be ideal because the offences are scattered amongst the laws. But we have already worked on this stalking proposal for some time, and I have already reported to members the progress of our work. It doesn't mean that stalking cannot be tackled. At the moment, Mr. Ip asked about debt recovering activities. In 2011, under the Moneylenders Ordinance, there was an amendment. I'm talking about the Moneylenders Ordinance. In terms of licensing conditions, there was the amendment saying that you cannot harass other people. After that licensing condition was put in 2011, we could see some improvement with the figures. Next one, Ma Fung Kwok. Thank you, Chair. On the administration's decision, I think some people will be disappointed, including my constituents. The performing sector has been very concerned. Well, we need to strike a balance between press freedom, news gathering, and other kinds of stalking. Now, you say there won't be any legal enactment. I'd like to ask what victims can do and how they will be protected. Let us just talk about last Friday. I understand some of our members, after leaving the chamber, could not leave because they were blocked in the car park. And even when they walked out, they were pursued by some people and they were scolded and abused orally all the way to the MTR station. Are you talking about me? Not just you. I think other colleagues had that experience. And also Mr. Wang Ting Kwang sitting behind you. What is the administration's view on this kind of stalking behavior? I also experienced this for a few days. We were talking about the TV or free-to-air TV license applications, and whenever I left this building, I was exposed to some oral abuse. What about the performing sector? Do you think they have got equal treatment? If you don't enact the law, what measures are there to protect the entertainment sector? Undersecretary. Thank you, Mr. Ma, for your comment. Actually, at the last meeting, Mr. Ma made the same point. If LegCo members are coming to or leaving the Legislative Council on official duty, if they are disturbed or harassed, according to the LCP&P ordinance, then there is this provision saying that if anyone attacks, harasses, or resists any Legislative Council personnel in the execution of his or her duty, then there will be a contravention. And indeed, last week, the police arrested some people on this count. So if you ask me, without the stalking law, whether we can still enforce the law, then it depends on the situation. But what Mr. Ma cited can really be dealt with by the P&P provision. Then I can ask you this. How can you teach our chairman because he said he was a victim? What should he do? Undersecretary, Mr. Ma, I don't think the chairman needs my instructions or coaching. The chairman himself will make a judgment. But what about the entertainment sector? Sometimes they are stalked, and you know, the stalking can be quite outrageous. Sometimes people will jump onto the stage when there is public performance, or if it is a television artist, they could be pursued whenever they leave the building of the station and they are harassed by telephone calls, etc. Undersecretary, in our criminal code, there is loitering and also making calls that are obnoxious to the recipient and also sending letters with prohibited articles, etc. These have taken place, and under our criminal code, we can pursue such behavior. But here I'd like to add, the Privacy Commissioner has spoken on this. He is of the view that without the stalking law, they would like to do something but could not do it. I can give you an example, and Mr. Ma may be interested in this as well. There was a complaint from an artist who was filmed nude at home. In fact, 3 or 4 days. In fact, it happened for 3 or 4 days when the Privacy Commissioner took this up with the photographer of the magazine concerned, and an enforcement notice was issued asking him to delete the photos.
However, it's not effective. The problem had not been resolved altogether. So the Privacy Commissioner was a bit disappointed. He's of the view that there are a lot of things that his department could not take actions without the stalking law. So, Undersecretary, what's your consideration? Chairman, we are making attempts to find a solution. So today we are here to listen to your views. Chairman, you may remember that LRC did not only propose anti-stalking law. There are other things regulating the paparazzi's actions. So laws have been proposed. However, in relation to the anti-stalking law, we want to explore what should be done. And we encountered the same problem. The public attaches importance to freedom of the press, and there are controversies that cannot be resolved easily. On the other hand, we hope that whenever laws are made, we have to make sure that we are equal to all potential stalkers. So we must give an account to everybody. While things may not be very satisfactory, but we would like to listen to your views. We are not happy with the present situation, but what should be the way forward? Legislative proposal tabled at LegCo must be agreed to by most. So far we haven't seen an arrangement that is acceptable to most. Yes, there will be different views, but I suggest that you can talk to the Privacy Commissioner since he has expressed his views in public. When you worked on the anti-stalking law in the past, that was because certain things had happened. Now, you're saying that you won't legislate, but then this doesn't mean that those incidents, those problems had disappeared. So I think the government should continue to do some studies. You will continue to listen to views, yes, but then there are problems that cannot be resolved. So shouldn't you consider to identify solutions? Okay? Okay. We are done with the first round of Q&A. Any other members? Mr. Chan Chi-chun. Thank you, Chairman. To enact laws against stalking, well, we have discussed anti-stalking laws for a long time, but we don't want to sacrifice freedom of the press. We don't want to sacrifice public rights to monitor the government or the media's right to monitor the government. So that's why we are giving up the anti-stalking laws. However, when there are genuine stalking activities, now I can give an example. There are divorced couples or separated couples. So the former spouse may engage in stalking. He or she may harass the other person by making visits to her homes and making phone calls. So can we expand the scope of domestic violence law so that former family members or former cohabitants' harassments can be better handled? Undersecretary, Chairman, Mr. Chen should be able to remember that some time ago the domestic violence law was amended and the relationship was actually broadened to include harassment. At that time, you may remember that this is only restricted to civil liability. At that time, some members asked whether things should be criminalized. At that time, the approved amendment is only a civil liability. So that's about the domestic violence law. Mr. Chen, any follow-up? I want to point out a relationship involving former lover or former family member. Even if it is civil in nature, can it be broadened to give better protection? Is there some room in this law? Chairman, if you only talk about expanding the scope of the relationship, well, this was already done in the last amendment. If there is no other member in the first round, then second round, Ms. Claudia Mo. Thank you, Chairman. I hope you won't misunderstand that without stalking law, then it means that stalking activity is legal. It's illegal. There are many other ordinances as spelled out by the administration. So I think these can be governed. I've got a big file. Okay, I'm happy that you are withdrawing the proposal. I can argue with you case by case. So there are court rulings concerning moneylenders or continuous phone calls or ex-lovers and so on. Please don't think that making continuous calls is okay. It is illegal. This is about stalking and about the entertainment sector and the paparazzis. This is not something new. It has lasted over half a century. If you are a pop star, if you are a senior public officer, then you are in the public eye. Basically, you cannot escape from that. I would like to remind Mr. Ma Fong Kok, you said that the entertainment sector, the artists, the performing arts sector is very disappointed because this anti-stalking law will be shelved. I think Mr. Wang Wai-K's inability to get the license is most disappointing. Now, some pop stars don't even dare to go outside with their babies or with their domestic helpers. But then we're not only talking about hard news or public interests. We will have to cover things of public interest. You may say that people are only nosy, but actually, those pop stars have a lot of fans. Only when you are popular will you be followed by many fans. You may say that I am cold-blooded, but then sometimes some paparazzis are really doing too much. I have got a whole file of cases. If you are doing too much, then you are infringing upon people's privacy. Please don't think that from now on everybody in Hong Kong will be naked, everybody will be stalked. That's not the case. I don't agree with the administration that in society people insist too much on or are too stubborn about freedom of the press. Well, this is not a choice. This is a universal standard. With such a law, even if you say, oh, don't worry, in the court you can use public interest as a defense. But why is it necessary for me to argue with you in court? That will be like a black cloud on the news workers' heads. So how can they do their job? Besides, taking pictures in a secretive manner, some time ago, the Journalists Association insisted on that. People may be saying that it is very bad to take photos, for example, of ladies, private parts, and so on. Professor Chen Minman of Hong Kong U tried to pacify the media that they can continue to do journalistic reporting in the court. Just say that you are working for public interest, then you will win. But then in the future, we don't know in the future when we will have to appear in court. When do we have to argue with you on public interest? Well, that's before your term about criminalizing secretive photo shooting or photographing. But then you're talking about overseas experience. But in other countries, there is stalking law. There's anti-stalking law. So why don't Hong Kong be more international? We have a unique legal system. We have one country, two systems. I think we have not reached a stage as the Western civilized society. So that's why we suffer from this problem. So this time I do understand, I do appreciate, I do sympathize with the government's approach. Any response from the Undersecretary? No? Mr. Chen Wafeng? Chairman, thank you. In para 13 of the paper, so it is about divergent views on the different approaches of enacting anti-stalking legislation. So the government is shelving this legislative work. But then we're talking about cases in which people's sense of safety will be threatened. So how will the government face up to these issues? Recently, I received a complaint from a security company saying that there is an employee in our company who had owed other people a big debt. And so many people have been harassed by the creditor. But then that employee had already resigned, and we have stated clearly that that is about that person individually, not having anything to do with our company. But still, employees have been harassed by telephone calls, and then the moneylender or the creditor had taken photograph at the company entrance and also of our employees. So even though the security company had reported to the police, the problem still had not been solved. So I want to ask the government, how can you protect the innocent victims so that they won't be unduly harassed? In the past few years, there are a lot. I want to know how many cases are there in which people are being harassed by moneylenders or creditors. Is there an upward trend? Undersecretary. Thank you, Chairman. So you're talking about harassing or harassment because of debt collection. We have heard about that very often. Recently, if you refer to the moneylender ordinance in 2011, in the licensing process, there was some amendment. The licensing authority, upon licensing, must review the moneylender or the debt collection company to make sure that they won't harass other people. They can't harass other people. So if there is such a case, I encourage people to report to the police. The police has some say in whether or not license can be granted. You just ask for a figure concerning debt collection activities. In 2011, there's a change. So debt collection agencies cannot harass other people in 2011 or 2 years before 2011. And also 2 years after 2011, I can give you the figures for you to compare. In 2009, about debt collection activities, criminal reports about debt collection activities, 2017 cases. In 2013, 1,538, 1538. Non-criminal harassment and reports about debt collection in 2009, there are a total of 16,186 cases. In 2013, 8,796. So you can see a comparison, a contrast. So such change is such that debt collection agencies have to consider whether their behavior, their acts will contravene the licensing conditions. So if there is such situation, please report to the police. Now the securities company is running or doing its business in a proper way, and recently that securities company's business is not good. Now, many employees are still paying their mortgage.
So they have insisted on operating even if the situation is not good. However, debt collectors also have some legal knowledge. They would not overstep. They will call you up and say some slang words, and then they slam the call, and they will also put up big posters around your company. But it seems the police cannot do anything about this. So I think there is a loophole in the law that the law is too lax. Even if you do not legislate on stalking, you should do something to stop such behavior. Okay, that's a remark. Mr. Wong Yuk-man. In the year 2000, the LLC released the report, but there has not been a consensus reached, and after a decade or so, the administration is proposing to shelve the proposal. Many people think you are responsive, but I don't think so. We requested that even if there will not be a general anti-stalking law, because of a lack of consensus, you should legislate on specified areas. You say it is not possible, and then you asked us to look at 14.2 of BORO, saying that everybody should have the right to be protected by law, etc. And therefore, you refuse to legislate on specified areas. In fact, with regard to a flat recovery or debt recovery, you can resort to the Landlord and Tenant Consolidation Ordinance, and also Hong Kong MA's guidelines, and also guidelines on the engagement of debt collectors by banks. Now, if that's the case, why don't you say this flouts the principle of everybody being equal before the law? This is also about a specified area. I think what you are doing this time is problematic. Originally, I think now that the stock proposal was targeted at the press. In fact, me and my family have been victims of stalking, but I have said many times that I object to having an overall anti-stalking law. I think the authorities should only target specified areas and legislate against stalking, and also expand the existing legal scope and increase the penalties. You should also provide appropriate help and support to the victims, for example, before landlord and tenant and money lender and borrowers. These are very commonly seen cases. On the basis of existing law, if you can expand the scope, or you can increase the penalties, or you help victims to get relief or compensation, then that's good enough. Generally speaking, we welcome the shelving of the stalking proposal. We welcome that. But the administration can consider specified areas, as reflected by the questions of some members. The situation is still quite serious. You have to think of ways to tackle it. You just cannot say we are not going to do anything about stalking and then you don't do anything about certain specified areas. That's what Mr. Christopher Chung said. Also within the family and also between ex-lovers. Especially we use the smartphones. There are so many ways to communicate with other people. If there are ex-love affairs, one of the partners can send hundreds of messages to you every day, so you get nervous. So the Secretary has to think about this. The stalking proposal has stalked us for too long, and yet there is no consensus. Okay, I grant you that you're responsive. You're not making an anti-stalking law, but you cannot just turn a blind eye to stalking behavior that really disturbs and harasses people. You must think of ways to improve the system. So, Under Secretary, what is the administration going to do? There won't be a comprehensive law, but individual stalking behavior that is specified. Can you do something about those? Under Secretary, indeed, such behavior scatters in different laws, and it is regulated. Mr. Wong mentioned the Landlord and Tenants Consolidation Ordinance and the Moneylenders Ordinance, etc. So there are regulations already. It is just that the LLC would like to have an umbrella law to cover this. But as I said, we have met up with many problems. But Mr. Wong is correct in saying that as times change, we need to amend certain laws. For example, you mentioned the Landlord and Tenant Consolidation Ordinance, and indeed it was amended in 2002 to increase the penalties. And also we have amended the licensing condition for money lenders. That was in 2011. Licensing has been tightened up. So things are developing. You actually also mentioned the specified relations and have all the elements of stalking attending to these three relations. Well, we have looked into the matter. We don't think it is feasible. You also mentioned other scenarios, for example, calling up people all the time and posing threats by text messages, etc. All that can be covered by the criminal code. And in fact, just last year, there were cases that were convicted and criminal liability was distributed. So it is not that without a stalking law we have no way to regulate such behavior. Okay. Any other questions? If not, the meeting can adjourn here. Really? Yes. The next meeting will be the 21st of July at 2:30. Anything under AOB? If there is none, then meeting is adjourned. Thank you very much.